They were so frustrated with you that they said they will not do a pre-sentence report while you're on bond. So do you know what that means?
My bond has to be paid off.
No, that means I'm gonna revoke your bond
Okay.
and you're gonna go to jail.
Yeah.
And then they're gonna come to the jail and do the pre-sentence report. And you're gonna be respectful to them. Or I don't have to go along with this plea agreement.
Yes, ma'am.
So listen, it's time to get a whole different attitude about all of this. I understand. I remember now when you were here, you don't like the whole situation.
No,
Hang on, don't overtalk me. Because that's gonna show me what you're doing to them, okay? Now it's just the time to listen,
Yes, ma'am.
all right? And just do what you're told. There's not an excuse for what you did. That's not, you didn't just try to ask for some information, okay? They wouldn't have sent this. They're very, very patient.
I just want to let you know I got a whole different view about it on the whole situation now too. I just got to meet my son for the first time on Friday, so.
Well, this is very unfortunate.
Yeah.
So you'll, but here's the thing, there's no reason for you to still not get this probation, but I don't have a choice now but to get this pre-sentence report done. So I'm going to, hang on, I'm going to revoke your bond in your case at this time. You're going to go with the bailiff. Probation's going to come to the jail. They're going to do this pre-sentence report, probably not today.
Do I get a new bond today?
I'm not giving you a bond because you couldn't act right while you were on bond, which shows me that you see where I'm.
Yeah,
the
can
problem-
we just like revoke the deal and take it to trial? I can't afford to go to jail, please.
You're going to jail regardless. Why?
Yeah, it's
Because,
not-
do you want me to read the memo?
The whole thing, yeah, can we play the voice recordings of the phone call in here today too, if that's the case? Because if you're just gonna believe what she says, then I believe I have the right to fight on behalf of what I have to say, and we need to be able to play those phone recordings.
You're gonna
in court
go
today.
do that, you're gonna go do that
Of
pre-sentence
course, we're not gonna
report.
play phone recordings today.
And you're gonna go and hopefully be respectful and hopefully get this probation and not ruin your life over this. This is very-
How long if you think I'll be in
It's
there?
a very temporary situation, Mr. Rojas can.
Yeah,
I'm okay. How are you?
very good.
So you're Corbin Rayleigh?
Yes, ma'am.
And Mr. Rayleigh, you were here just last week or the week before.
Yes, ma'am.
And you pled guilty to an offense and you were told to go to the probation department and do a pre-sentence report.
Yes, ma'am.
And I've gotten a memo from them that has some unfortunate information in here about how you
Yeah.
acted while you were there and visiting with them.
Yes, ma'am. It was over the phone when the lady was arguing and stuff. I just wanted the information on when I was supposed to meet the dude. That was it. And
That's not how this reads.
there-
Initial appearance and cause number 26 DCCR 1106. You are charged with aggravated assault with a deadly weapon from May 17th of 2026. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? So what I'm going to do, Miss Williams, is reset your case about 30 days to give you some time to try to hire someone.
I need a court appointment.
Well, so once you've made a bond in your case, I expect you to at least try to hire an attorney. And then, are you working?
No,
Why not?
I'm disabled.
Do you get disability?
Yes, ma'am.
How much do you get a month?
1,000, but my rent is 1,000 something.
Now, what is your actual check?
I get 2 checks. I get my husband, cause he died. I get his, I get mine too.
Okay.
So
What's the total?
I think like 1,200.
How do you not know what the total is that you get every month?
Because his is eight something and mine is 670.
Okay. All right. I'm going to have you fill out some paperwork this morning. Miss Williams, you need to fill it out accurately and completely because you're going to swear under oath that it's all true and correct about your income and your expenses. And then I'll take a look at it to see if you qualify. Step in front of the clerk.
Yes, ma'am.
And Miss Elliott, this is your initial appearance and cause number 26 DCCR 0618. You're charged with a 3rd-degree felony offense of financial abuse of an elderly individual from October 21st of 2025. Since you've made bond in your case, if you had an opportunity to try to hire a lawyer?
No.
All right. So what I'm going to do, Miss Elliott, is reset your case for about 30 days to give you some time to try to hire someone. Well, same thing I just said. If you bond out, then I expect you to try to hire your own lawyer. Are you working?
No.
Why not?
Just a part there.
Do you receive disability?
No.
Then how do you pay your bills?
My son passed,
Okay, is that how you got out of jail?
my sister.
So what I'm gonna do is have you fill out some paperwork, Miss Elliott, to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely because you're gonna swear under oath that it's all true and correct, and then I'll take a look at it. You need to step in front of the clerk on the end and she'll give you that paperwork. Appearance and cause number 26 DCCR 1070. You're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from April 3rd of 2026. Since you've made bond in your case, if you had an opportunity to try to hire a lawyer. Right, so what I'm gonna do, Mr. Henry, since you've made bond, is I'm going to reset your case for about 30 days to give you some time to try to hire a lawyer. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers you talked to, so I know you're trying, and we'll discuss your options.
Right.
If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you'll go back to jail. Do you understand? All right, step in front. Are you Wakeisha Petrie?
Yes, ma'am.
And Ms. Petrie, this is your initial appearance and cause number 26 DCCR 1032. You're charged with a state jail felony offense of credit or debit card abuse from March 7th of 2026. And since you've made bond in your case, if you had an opportunity to try to hire a lawyer.
Mhm.
So I'm gonna, same thing you've heard me saying, I'm gonna reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do.
Okay.
If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me the names of the lawyers that you've talked to, so I know you're trying, and then we'll discuss your options.
Yes, ma'am.
If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order and you would go back to jail. Do you understand?
Yes, ma'am.
All right, step in front of the clerk. She'll give you your hired.
I haven't hired one. I've talked to 3. I don't know if you received my email. I don't have a vehicle. Had 1 repossessed and 1 stolen.
Who'd you talk to? What
I talked
lawyers?
To there are 3 Houston firms, Martinez Law Firm. They gave me their payment plans and the estimated cost based on my cases. Huff Law Firm in Houston and Dunbar and Jones. And I've also looked into something called case funders that will allow me to borrow the money to pay for an attorney.
Do you, thank you for doing what I asked you to do. Do you want to fill out the paperwork this morning to see if you qualify for a court-appointed lawyer? Or do you want to see if you get that money and hire your own with 1 more reset?
I'm living on unemployment right now, which is about $1,000 every 2 weeks. But there's.
It's okay. I just need to know if you want to fill out the paperwork this
Yes.
morning or if you want to get 30 more days to try to hire someone.
If I could have 30 more days, I would appreciate that because I think I can get a vehicle and get a job.
I'll reset you 1 more time, and then if you make sure you talk to some other attorneys, bring back any information you have with regard to if you've gotten a job, and then we'll see what your options are if you don't have someone. Step in front of the clerk, please.
Thank you very much.
Yes, sir. Varenus McIntosh. Good morning, sir. Is it McIntosh or Tosh? McIntosh, you're Varenus McIntosh. Mr. McIntosh, this is your initial appearance and cause number 26 DCCR 1090. You're charged with the 3rd-degree felony offense of failure to comply with sex offender registration requirements from May 20th of 2026. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I called one of Lane Walker.
Uh-huh.
He wrote $10,000 and I'm gonna be looking for somebody else.
So what I'll do then, Mr. McIntosh, is reset your case about 30 days or so to give you some time to see if you can get someone hired. If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do.
And can I ask you a question?
What's that?
I know I've been registered since 18 and I know it's a lifetime. Is there any steps that I can go through that I was looking up online that I can possibly get
You're
off
gonna
the
have to talk,
registration?
you're gonna have to talk to a lawyer about that. So let's get through the case first, and the lawyer you get, also talk to them about that. There may be some options for that, but that's not something that I'm not allowed to give legal advice.
Okay.
So if you get someone hired, again, bring that reset notice to them. If for some reason you don't get someone hired, make sure you talk to at least 3. Bring me back those names so I know who you've talked to, and we'll discuss your options.
Yes.
Okay, step in front of this. You were here before and I tested you and you tested positive. And I told you to get a drug patch. Did you get a drug patch?
Yes.
Have you had it tested?
No.
Have a seat in the jury. DCCR 0914.
That's correct, John.
Good morning, Your Honor.
Good morning.
Mr. Naismith had filed,
Second. Good morning, ma'am. You are Deshawn Robertson.
Yes, ma'am.
And Ms. Robertson is charged with aggravated assault with a deadly weapon, and there is a motion to modify or delete a bond condition that was filed with regard to
It's,
not driving a car.
correct, John.
and Your Honor, we've discussed it. I've looked at it. I don't have any opposition to letting her drive for those limited reasons that were requested.
These are regular NHMR appointments, Your Honor. These are any doctor appointments for her youngest child who's still in school. Her youngest child goes to school near Nederland, Texas, away from here in North Beaumont, where she currently lives. And she's also on GPS and employed, Your Honor. GPS is current as well.
The reason the driving was added at the beginning, Judge, was the assault involves hitting someone with a car.
Okay. That's good. Yeah,
It wasn't an intoxication situation. Your Honor.
okay. So you are working or you're not working?
Yes, ma'am, I'm working.
Where do you work?
I work at Rose's. I'm a customer service manager.
At Rose's?
Yes, ma'am.
Where's that?
On Concord in Beaumont.
And where do you live?
On Thames Street in Beaumont.
THAMES?
Yes.
Thanks. It's just the order setting a hearing. Oh. And your child goes to school where?
At Evolution Academy.
Right, Mr. Nichols, you have no objection.
I don't, Your Honor. I reviewed his motion. We discussed it over the last few days, and I don't have opposition to lifting those conditions.
The NHMR is at the Spindletop location as well, Your Honor.
Right.
Sorry, my apologies.
Yep,
I keep forgetting.
and that's in Beaumont.
Correct, John. Yeah, let's go. Spindletop.
Okay, so here's what I'm gonna do. I'll grant the motion to modify the condition. I am going to allow you to drive. It's still gonna be for limited purposes though. So it's gonna be go to work, take kids to school, and go to any medical appointments, either doctor or medical through Spindletop, right?
Yes, ma'am.
That's it.
Yes, ma'am.
Other than that, you need to be at home.
Yes, ma'am.
Okay, and not driving around town and obviously not having any contact at all with the complaining witness that we've already talked about.
Right.
Okay,
Yes, ma'am.
anything else?
Nothing.
Okay,
Not this point, Judge.
okay. All right, then I'll just reset your case for an announcement, give you some time to get all of the evidence. Make sure you visit with your attorney before all the discovery. Make sure you discuss all of that. Brooke, Zarek, and then this is cause number 26 DCCR 0317. Mr. Zarek's charged with driving while intoxicated with a child passenger. And what is the announcement?
Yes, Your Honor, we've received the offer in this case. We're just asking for additional time to.
I have no issues, Your Honor. I've given 2 alternative offers and that may allow some time for them to get some mitigation documents for me.
All right, thank you. So we'll just do a normal reset. It's about 30 days or so. Make sure you stay in touch with your attorneys. They'll let you know when you need to be back. You can visit with them between now and then about all of the discovery in your case, and we'll see. And this is 24 DCCR 1460. Ms. Pratt's charged with theft of property with previous convictions. And what's the announcement?
Your Honor, I believe we have a deal worked out. I would respectfully ask the court depending on what the court wants to do. If you see her foot, she has one more doctor's appointment. We can either plead today, and I would respectfully ask for sentencing without a PSI to be set, maybe 30 days, or we could reset it for a plea, but
Oh,
That's
is
where-
the agreement for some kind of time?
12.
What I'd like to do while you're here is go ahead, we can do the plea
Yeah.
and I'll reset it without the pre-sentence report. And then we can set a sentencing date based around a typical time for a PSI is about 45 days. If that gives her time for that last appointment, we can do that.
Yes, sir.
Okay, I'll hold it while y'all take care of that paperwork.
Yes, sir.
So, Mr. Patterson, you tested positive for THC. There's no reason you should have tested positive if you had stopped using before when you were in court last time. So obviously you're not doing what you're supposed to be doing with the drug patch and staying clean. So you give me no choice at this time but to raise your bond in your case. Let's see, what does it say that name? Current is set at $7,000 and give me a second to look at this. I'm going to raise your bond in your case to $25,000. Condition of that bond obviously is going to be that you have a drug patch on, but you can't, it's not just a matter of going and getting a drug patch. It's getting it changed every 2 weeks and it's the drug patch being negative and you staying negative. So if you make that bond, obviously you cannot use anything that has any type of THC that would test positive, legal or not legal. And you have to have the drug patch on within 24 hours of your release from custody. You can go back with the bailiff. Good morning, sir. Are you Dan Church?
Yes, ma'am.
And this is 26 DCCR 0612. Mr. Church is charged with deadly conduct, discharging a firearm. And what is the announcement?
Judge, we're still working on this case. We've been here in one setting about a bond issue, which I think we've got sorted out, but other than that, we're still working through the discovery. I think that was only a couple of weeks ago. We're still working through it. I'd ask for a normal resetting on this.
Any
So he and I
issues?
could discuss.
Sure.
I have no issues with that, Your Honor. I have an offer that I can tender to counsel at the appropriate time. I would like the record to reflect that since that bond hearing, I have asked Ms. Tanner and she kindly sent me the transcript of that just so we could all be on the same page with regard to that. There have been no issues brought to my attention. And so we can just keep everything as is. I think hopefully we'll be able to resolve this.
Perfect. Thank you. All right, we'll just do a normal reset. Mr. Church, make sure you stay in touch with Mr. Kurtz so you can visit with him before that next court.
Thank you.
You're free to go. Mr. Gover, in cause number 24, DCCR 0512, you're charged with the second-degree felony offense of attempting to commit sexual performance by a child from August 2nd of 2023. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Ms. Busick?
Yeah.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 10-year deferred probation. There would be a $2,500 fine and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1. Any objection?
No objection.
It's admitted. Is there any evidence that Mr. Gobert is not competent?
No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's at that desk right behind you. So stop and talk to her on your way out, and then we'll see you back at sentencing.
Yes, ma'am.
Nice to meet you. Thank you.
Thank you. You as well.
That's right. Mr. Riley refused to submit to your analysis, had to be put in the chair because he was banging his head and being trying to hurt himself, and so I'm gonna go ahead and have him And he did admit also,
Smoking marijuana last
to at least smoking marijuana last night, if not anything else. So we'll go forward that way. Okay. Mr. Smith? Is Mr. Smith here? Who's Mr. Smith today? On Lisa Pratt?
Excuse me, screen.
Yes, sir. Thank you. Yes, correct. That's to do this, get the pre-sentence report done. Do you mind signing that for him, please? All right, ma'am, you're Lisa Pratt, and will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Pratt, in cause number, no, I have me pull the right one up. I'm sorry. Okay. And are we just going on count one with the,
We are, Your Honor.
okay. Ms. Pratt, in cause number 24 DCCR 1460, the state's elected to proceed on count one only. It alleges that you committed the state jail felony offense of theft of property with previous convictions from April 1st of 2024. It further alleges that you were previously convicted of theft June 30th of 2023 in two different cases on that same date. And how do you plead to that charge? Speak up.
Guilty.
Are those prior convictions true?
Yes.
Did you enter your plea of guilty and true freely and voluntarily? And did you plead guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lane?
Yes.
Do you fully understand them?
I do.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal? And also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? And the agreement that you've reached, it looks like it's for a 12-month term in the state jail prison. And you guys have asked me to reset your case for sentencing for a short amount of time so that you can have a final appointment with regard to the issue on your leg or your knee. Is that correct? Or ankle? Ankle. I want to make sure you understand. How long, when's the next appointment?
August the 20th or something. Yeah.
Ma'am?
It's not till August.
Okay.
You said August 24th.
I might can get it moved out. I mean, I don't know how that falls. Today's the way.
All right. You'll think of- Okay, so I'm going to state tenders number 1.
No objection, Your Honor.
It's admitted any evidence that Ms. Pratt is not competent.
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily.
Yeah.
Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case for sentencing. I don't need a pre-sentence report. And I will reset it to the August the 31st. It's a Monday. There's a few things that are very important about that. So if you are arrested for anything between now and that court date, I do not have to accept this plea agreement. Things could obviously be worse. Do you understand?
I do.
Also, if you don't show up for that court date, obviously things could be much worse. I don't have to accept the plea agreement. You understand as well? All right, then we will see you back at Senate. Cause number 26 DCCR 0403. The state has elected to proceed on the lesser included offense of a Class A misdemeanor evading arrest or detention, and that is from February 8th of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
And it's for 30 days in jail that would be sentenced today. Is that correct?
Well, she has a job. Explain to the judge.
Well, I mean, I just got a job. It's really hard for me to get a job, I guess, because I'm an age. And so I really would like to put in 2 week notice. It's for Cal Cam. It's like just flagging a parking lot, but it's $15 an hour. So I've been looking for a job for a month. So if I put in a 2 week notice, then maybe they would hire me back. I mean, just because I haven't done that.
Okay, so we just need to reset for sentencing for 2 weeks. Okay,
You don't show up.
I'm coming out to here.
well, I'll go through that with you just a second. So it's for a 30-day jail term and, are you a US citizen?
Yes.
State tenders number 1. It's admitted. Is there any evidence that Ms. Odom's not competent? All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for 2 weeks for sentencing. So that'll be on Monday, the 27th of July. And so you'll need to be in court that morning. We'll go forward with sentencing at that time, and then you'll go serve your time. It's very important, obviously, that you're here on that date. If you don't show up, I don't have to take this agreement. Things could be a whole lot worse. Also, if you are arrested for anything between now and when you come back, you run the risk of me not accepting the plea agreement.
Yes.
Do you understand?
Yes.
All right, then we'll see you back at sentencing in 2 weeks. Maria Morel. Speak up, please. Maria Morel. Thank you, Ms. Morel. Would you please raise your right hand? You swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English?
Yes.
Thank you. Sir, are you Jose Lopez?
Yeah. Yes.
And Mr. Lopez's case is set for trial. To begin with jury selection next Monday. In cause number 25 DCCR 0211. Charged with solicitation of prostitution. And what is the announcement?
Your Honor, I would be ready, but I have the appointment by retina doctor in the Woodlands on the 22nd. It's taken me like 2.5 months to get the appointment. I haven't been there in like a year, so I need to go.
Did you file a motion for continuing?
No, it's set at 2 o'clock. I just checked my calendar this morning on that. I mean, I can file one. I could pick a jury, but I will be unavailable Tuesday to try the case. I could come back and try it Wednesday.
Okay. Ms. French.
State's ready, Your Honor.
Okay. And so your appointment is on the 21st?
22nd at 2 o'clock.
The 22nd is Wednesday.
I think it's
Wednesday.
the 22nd. It's the 22nd. It's not the 20th, it's the 22nd. Saturday, Wednesday. I was thinking it was Tuesday. Okay. At 2 o'clock. I know that. What did I tell you? Have I told you? No. I'm gonna drive. She's gonna drive me. I guess.
Yes.
I'll let your eyes. You can't see when you.
So I guess if we needed to, we could pick a jury Monday afternoon. We could work Tuesday afternoon, possibly even part of Wednesday morning, a couple hours, maybe
Yeah, so I'm on the road about 11.
11. And then we have all day Thursday. So we still, I would think on this type of case, have plenty of time.
Yes, Your Honor.
Okay. And it looks like the rejection before was for a 3-year deferred probation. Mr. Lopez, I want to make sure if we go forward with trial next week, that I will not accept any plea agreements after today. Do you understand?
Yes.
And do you still want to reject that offer for probation and go forward with a jury trial? Okay. All right, then I will number the case tomorrow after docket. If we do go to trial, will you have your own, you'll have your own interpreter for him?
She translated.
Okay. Okay, all All right, we'll see y'all next week. Stay in touch with Mr. Kimler. He'll let you know what time to be back or what order the trials are. To theft of property with previous convictions. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, sir, we have.
Any additions or corrections?
No, Your Honor.
All right, Ms. Bell, how old are you?
25.
You're 25 and you're already adding up some history that started as a juvenile. I'm going to go along with this agreement. And I really, really hope that you use this as an opportunity to do better for yourself and to break the cycle of what's been going on with you and your family. Looks like from what I can tell, everybody in your family's been to prison or in trouble. And so you can at some point continue doing all of that stuff and end up like that, or you can say, I'm gonna do something different with my life. And that's gonna be up to you at this point at your age, right?
Yes, ma'am.
It's not fair that things happen the way they did, but you're an adult and so you can make those decisions for yourself at this point, right?
Yes, ma'am.
So I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made and find you guilty of theft of property with previous convictions. Sentence you to a term in accordance with your agreement to a term of 2 years in the state jail prison, but I'm going to probate that. You'll be on probation for 3 years. You're ordered to pay the $500 fine as well as the $221 in restitution. And actually what I'm going to do today is I'm going to reduce that fine to $250. I want you to succeed. And I don't want the money to be the issue. I want that restitution paid off first.
Yes,
Okay. I want you to get a job and I want you to pay that off as quickly as you can. And then do everything else that you're supposed to on probation. If you do everything you're supposed to, then for all practical purposes, your case here in court's over and you'll be able to serve that 2-year sentence while you're out on probation.
Yes, ma'am.
The other side of that, though, is if you violate any condition of probation, you'll be brought back into court, your probation revoked, and you'll be facing that 2-year sentence that you've already agreed to. Do you understand?
Yes, ma'am.
All right, I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with Mr. Kimler. So if you'll just have a seat here in the courtroom, probation's going to call you up to her desk to go over your paperwork. Okay, good luck to you.
Thank you, Your Honor.
You've got, did I just hear you call Del? Okay, I'll do that in just a second. What about Angel Mata Rodriguez, Mr. Kimler?
This is a probation matter now.
This is Mr. Smith's on Angel Mata Rodriguez. Good morning, sir. Are you Angel Mata Rodriguez? And this is 23 DCCR 1106. Mr. Rodriguez is on probation for evading arrest or detention with the use of a vehicle. Motion to revoke's been filed. What is the announcement?
I anticipate being able to discuss it with Mr. Smith this morning, Your Honor. I don't know that we have that ahead. I think he's picked up a new case. Is that right?
Honestly, I don't know. Your Honor, Mr. Smith is around. He's dealing with crisis from over the weekend. He is here if we need him, but I've got his file and there's an
Why don't I hold it?
Yeah,
Y'all can just
I
take a
won't
look at
speak
it.
out to him.
Yeah,
All right.
and if he needs to run down or if y'all need a reset, just let me know, but I'll hold it for now.
This is not his.
I just realized this.
And then Jorge Del Fiero.
Wait. Your hands.
Discovery. Okay. Good morning, sir. Are you Jorge Del Fiero? And will your client waive the formal reading of the indictment?
Sure.
Mr. Del Piero, in cause number 25 DCCR 0892, you're charged with the third-degree felony offense of assault family violence by impeding breath or circulation from January 31st of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. You would be required to participate in AA as well as anger management, have no contact with the victim,
It's like I put direct contact. you know?
direct contact. You would be able to use the Family Wizard app or program to communicate with regard to your children. Do you understand? Okay. And do y'all use that already?
No, I go straight to mom, but I'm even having issues just to see my son.
Yeah, so it's a great, here's the thing, that is a great tool. It protects you and her both because it takes everything that it has a calendar. If there's a doctor's appointment, if there's a soccer game, if there, whatever it is, if you need to find out information, you can both input information. It's like an email program, but everything's saved. So everything
Yes.
you say saved, everything she says saved. She can't say you said something you didn't, so, and vice versa. So
And what if she tried to get in contact with me or like just without using the app? What do I do about that?
hang up and say, if she texts you, say, use Family Wizard. And that way, and keep that, forward it to your attorney so that if she comes back and says, oh, he contacted me, you can have whatever you need to protect yourself.
Yes.
Okay, I don't even
And
know.
also, I know she works. You know, her mom sells drugs and all this. She be having my son stay.
Objection. Your
So,
Honor.
here's the thing. If there's issues, you need to go through family court. All right, you need to talk to Mr. Kimler, get a lawyer, get all that worked out another way. I don't have any say so over any of that. All I have is say so over you. Okay, so if you want to stay out of prison on this probation, you got to follow these rules. And if you need to go take care of some other things so that y'all have rules to live by down in family court, then you need to get that taken care of as quickly as possible. Okay, so it looks like also,
Can I help you out, Your Honor?
yes, please.
Defendant will pay 100% of the cost for 5 years for the Our Family Wizard program. And also agreed for probation to do an assessment to help him with any needs they may be able to help him with, refer him to.
So pay 100% for both of them?
He's paying the total cost for 5 years.
Okay, and that's y'all's agreement?
Yes, Your Honor.
Okay, that's good because it helps everybody. All right, you understand that all of that is the agreement. Do you also understand if you're not a US citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No, Judge.
It's admitted. Is there any evidence that Mr. Del Fiero is not competent? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing.
Good.
You need to stop and talk to probation on your way out of the courtroom today, and she said, and sir, are you William Nesbitt?
Yes, ma'am.
And this is cause number 23 DCCR 2098. Mr. Nesbitt's charged with aggravated promotion of prostitution from February 5th of 2023. And what is the announcement?
At this time, we are not ready. I talked with the state, is a newly assigned case. So we're fine with giving the state a chance to review everything and then go from there in terms of doing a plea negotiations with this position.
And the reason, Your Honor, I noticed there was an offer made back in June of 24. Of course, that was before the arrest and incarceration in Harris County. The reason that Mr. Nesbitt's bond had been revoked and increased.
Okay.
And so I need an opportunity to review what's taken place
Sure.
with TDC and
make a new offer because obviously the 5-year TDCJ is off the table after that.
Okay, so let's do this. I'll just do a normal reset, about 30 days, give Ms. French some time to get caught up. She'll send you guys over, I'm sure, whatever information she has in an offer. Make sure you stay in touch with your attorneys so that once they get that information from Ms. French, we can get an announcement at that next court date.
Yes, ma'am.
All right, we're free to go. Thank you. Mr. Nix, you've got Alexandria DeLeon.
Yes, sure.
Good morning.
Good morning, Judge. How are you?
Good. Good morning, ma'am. Are you Alexandria DeLeon? This is 26 DCCR 0143. Ms. DeLeon is charged with assault on a peace officer. And what is the announcement?
Your Honor, we need one more reset. We have something verbally worked out. We're getting a few letters of recommendation to turn over to the state as part of the plea agreement. And also I'm waiting on a letter from Mr. Green that should be taken care of next month.
All right, so we'll just do a normal reset and Ms. DeLeon, make sure you stay in touch with, it looks like you were just hired in May,
Correct,
correct?
Judge.
Yeah, so we'll just do a normal reset, give you some time to get all that taken care of, and we'll see if we can get an announcement the next court date.
Thank you, Judge.
Thank you.
True to count one, it's okay. I was gonna do paperwork, but we didn't come to an agreement. I did send the appellate.
Did you send me something on that? I'm sorry. I didn't-
Yeah, I sent the appellate, sir.
It's here, I've got it. Mr. Nichols, it goes straight here. All right, so are you Angel Mata Rodriguez?
Yes.
And will your client waive the formal reading of the motion?
He will.
Mr. Mata Rodriguez, in cause number 23, DCCR 1106, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation November 13th of 2023 for the 3rd-degree felony offense of evading arrest or detention with the use of a vehicle. And that was a 5-year deferred probation. Is that correct?
Correct.
And it alleges that you violated your probation. Count 1 alleges that you committed the offense of driving while intoxicated with an open container, March 22nd of 2026. And is that true or not true?
Oh, true.
I'm sorry.
True.
True. Count 2,
We just want to award that.
not if it's unagreed.
Oh, okay. That's true. You're right. Sorry.
Count 2 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you became intoxicated March 22nd of 2026. And is that true or not true?
True.
And then count 3 alleges that you are behind in your court assessed fees as of April 29th of 2026 in the amount of $710. And is that true or not true?
Oh, not true.
Okay.
No, it's as of that date, not now.
Oh, was it? Okay, true.
It was true as of
Sorry.
that date. Okay.
Yes.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Correct.
And did you plead true to those counts because they're actually true?
Correct.
All right, then I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm going to reset your case so that the probation department can do an updated report, and we will come back for a sentencing hearing. Anything you think is important for me to know, be sure and get that information to Mr. Kimler. He'll present it to me on your behalf when we come back for sentencing.
Yes, ma'am.
And make sure do you need to talk to him today? Okay, just stay in touch with your probation officer. Yes, sir.
I have one question. I know I have the ankle monitor. Is there any way I can get a patch instead of monitoring?
The patch doesn't do alcohol. Yeah, so that's why you've got the scram device on, is because that's the one that tests for alcohol.
Okay.
Okay, so at least until sentencing, we're gonna keep it the way it is.
Yes.
Okay, all right, we'll see you back at sentencing. So why'd y'all do paperwork on Malik Ellis?
It's unagreed. There's one that counts.
I know it's for sentencing, but I see paperwork.
Yeah, I just did it. He's pleading open.
He already did. We're here for sentencing,
No, that was one we're gonna have a hearing.
but he already entered his pleas. It's just a hearing on sentencing.
He pled not true, that we split and he changed the plea to true.
Thank you
Okay.
for the paperwork because these changes the not truths, the truth.
Thank you.
Yeah. I just did it.
That's nice.
Is that the same one?
Appellate certificate is in there for you.
So it's now agreed?
No, it's no agreement, it's just pleading open.
Gotcha.
He's not happy, Judge.
You could have fooled me.
I just want to keep you informed.
Thank you very much for that information. Yeah. Which makes it all the more believable that he was not nice to probation. You know what else I want on him? Riley? Yes, ma'am. For sure. And substance abuse and assessment as well. Yeah, he admitted to at least marijuana, and there was some talk about fentanyl as well. So I want substance abuse as well as mental health, and he smoked last night. So I'm not sure if there's something else going on that has to do with that as well. So. All right, Malik Ellis. And Mr. Ellis was previously in court in cause number 1726733, entered pleas of not true and a motion to revoke probation. It's my understanding that there has been, that it's still, we're here for sentencing. I've gotten the pre-sentence report, but it's my understanding that he's going to enter pleas of true to some of the counts as changes pleas. Is that correct? And so will he waive the formal reading of that motion again?
So
So let's go through the motion again. Mr. Ellis, so it looks like before you pled true to counts 3 and 6, and you're on probation for the second-degree felony offense of aggravated assault with a deadly weapon. That was a 7-year deferred probation that was extended for 2 years. Let's go back. Count 1 alleges that you committed the new offense of possession of marijuana, a Class A misdemeanor on November 18th of 2025. And is that true or not true?
True.
Count 2 alleges that you failed to report to the probation officer your change of address. Is that true or not true?
Not true.
Count 2 is not true still. Count 3. I'm making the modification here on the agreed punishment recommendation. Mr. Kimler, y'all wrote in 2, but he pled not true to 2 just now. So I'm
There
gonna
wasn't.
He was going to.
on which counts he was gonna plead true to. Y'all wrote in 2. I'm marking through 2 because he pled not true.
And I'll put on evidence of that for the court judge.
Okay, and then count 3, he already pled true to. Count 4,
We abandoned, Your Honor.
state abandons. Okay, and then count 5 alleges that you possessed an illegal drug, namely marijuana, and that you were in possession of it November 18th of 2025. Is that true or not true?
True.
And then you already pled true to count 6. So today you've changed your pleas and pled true to counts 1 and 5, and you do that freely and voluntarily. And did you plead true to counts 1 and 5 because they're actually true? All right, then at this time, I'm going to find counts 1, 3, 5, and 6 true. And Ms. Malfino, you have evidence with regard to count 2?
Very briefly, Your Honor.
Yes, ma'am. And would you please raise your right hand, ma'am? Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And if you'll just state your name for the record, please, ma'am.
My name is Shay Kane.
Thank you, Ms. Kane. Go ahead, Ms. Malfino.
Thank you, Judge. Ms. Kane, would you please identify what you do for a living for the record?
Yes, ma'am. I'm a community supervision officer for the Jefferson County Adult Probation Department.
And how long have you been with the department?
I have been with the department for a year, but I've been a probation officer for about for years.
Okay, and do you have occasion to know a Malik Jamal Ellis?
Yes, ma'am.
Do you see him in the courtroom today?
I do.
And is he one of your probationers that you supervise for this court?
Yes, ma'am.
And as a condition of that supervision, was he read all the rules and conditions, gone over those with him of what the court expected his behavior to comply with while on probation?
Yes, ma'am.
Was one of those that he at all times provide you with an accurate address of a residence and location of his job, et cetera, so that the community supervision department and thereby the court could find him at any time?
Yes, ma'am.
And if he changed this address, was he told or informed that he needed to indicate such to the probation?
Yes,
Based on your review of your file and your contact with Mr. Ellis, the defendant, did he change his address and report such to you?
according to the offense report that I received on November 18th.
Hang on just a second. It's okay. We'll just wait till he calms down a minute. Maybe they'll come get him. All right, go ahead.
According to the offense report I received on November 18th, it had appeared that he gave the officers a different address on the report itself. And based on that, he had never told me about any different residential since I've been supervising him.
And based on your supervision, you also became aware that he was arrested and has now pled true to possession of marijuana back in November of 2025, correct?
Yes, ma'am.
Would this have been obviously in violation of his probation?
Yes, ma'am.
And in discussions between you and I last week, we decided not to bring a lab analyst to prove that up, even though we have the Trooper Lucio here in court today, based on the fact that 2 days later, he tested positive for said marijuana, correct?
Yes, ma'am.
And do you have some other thoughts that you would like to share with the court at the appropriate time with respect to what your position is as to continuing him or revoking him off this probation?
Yes, ma'am.
And can we hold on that for a second?
Yeah,
You do
yeah,
have additional for the court.
Yes, ma'am.
And Judge, I'd like to just wait following cross-examination, also ask at the appropriate time that with the thanks of the state, the trooper be released this morning. He's here in court.
Any issue with the trooper being released? Thank you so much for being here, sir. You're free to go. We appreciate you.
Thank you, Judge.
All right, Mr. Kimler, do you have any questions of Ms. Kane?
Just want to be clear. So he filled out some paperwork and listed an address that was different to the one he reported to you.
It appeared that he told the officers at the time he was arrested, what I read on the officer report, it was a different than what I had in my system. It was 845 Madison that I had, and it was a different address listed at the time he was arrested.
No further questions.
All right. No, ma'am, we're not. All right. Any other witnesses then?
I don't believe so. I'd like to cross-examine that witness if they're called, but
Yeah.
I think I know where that's going.
Okay. Do you intend to call any witnesses?
Well, I guess I can call Grace. She wants to talk, so.
Well, I mean, is it
Let's look at it like I should.
No, go ahead.
with regard to what issue?
Where's your grandmother?
Oh, she was just there for the change of address part. She just there for support.
Okay, that's fine.
What explanation? I'd call Mr. Pelletin.
Raise your hand. Well, did they already swear you over here today? All right, go ahead.
What explanation do you have for the difference in the addresses?
It must have went off my ID say my mama address, but I stayed with my grandmother. When they came to pick me up from my warrant, they picked me up at 845 Madison.
Okay.
But your driver's license, your ID says what?
4751 Elton Road. That's my mother's house.
Okay.
But that's not where you
I
stay.
stay with my grandmother, which is the house that's on fire.
Okay. You know, it's a law that you change your license when you move. So you can see the kind of issues that gets you in if you don't, right? So it's very important that you take care of that. All right, anything else with regard to the actual counts?
Not from the state.
Okay, then at this time, I'm going to find counts 1, 3, 5, and 6 true. Find sufficient evidence to find Mr. Ellis guilty. Mr. Kimler, what is your position with regard to punishment?
Well, Your Honor, this is from 2017, so I guess he's been on probation. I'm approaching 10 years perhaps. I think it was extended one time. Obviously he's had issues on probation, his latest one having to do with marijuana. I would just observe that he was negative today in court on the drug test. I guess he has at least refrained from using marijuana since this last incident and the last time he was tested. And tested positive. The court, as it's presented, has the options, is presented to either keep him on probation or let him discharge or revoke him. I think there's a middle position where he could be unsuccessfully discharged from probation without being revoked. That may be an option that the court would explore instead of having just at the end of this period of time revoke him and send him to the penitentiary. There's an option to unsuccessfully discharge him from probation. And that would be what I would suggest if the court's inclined not to let him to sanction and not let him stay on probation, but to unsuccessfully discharge him from probation in lieu of revoking him and send him to the penitentiary. Is there anything you want to tell the judge?
How long, hold on. What's the time frame on getting the MRT class done? How long is that?
How long is it?
Process.
It's about 18-week course. It's in the probation office itself.
How many weeks do we have left? Is that something that if could he get started on that next week? If that's, I don't know if that's where I'm going, but.
Yes, ma'am.
Hold on.
We would just have to buy the book, and so we can get him into the program.
Ms. Malfina?
Judge, I would defer to anything Ms. Kane has. We've spoken multiple times about the case. I know she's tried everything. I'd just like her to let the court know her thoughts.
Well, we can't extend again, can we? Or is there any time frame left?
So he's at his 9 years.
So we could do one more.
At the very, yes, ma'am. That would be the max that we
Gotcha.
have left.
Okay.
And he has also been to ISF cognitive track as well. But as far as what I would possibly recommend would be to put him on the high medium risk caseload for the rest of the entirety if the court allows, 0 tolerance, and possibly place him on the drop program to continue the more in-depth testing if the court would allow.
Anything else? Ms. Malfina to add to that?
Judge, I don't have much. Of course, I would defer to Ms. Kane and the court. Obviously, the state is somewhat frustrated with Mr. Ellis not taking initial responsibility. That's what I think people should get favor for instead of having the trooper have to be here. And thankfully, we didn't have a $3,000 plane ticket for a lab analyst to then what he then wanted to come in and admit. I would have rather him taken responsibility. And I don't say that in the context of disavow him of his rights to contest it. It's just that if he's
No, it's
not,
a very frustrating.
if
thing
he's
for
not
me
being
as well, and
forthright with the court, should he have the benefit of the continuance on probation is all, not in the context of a not true. I understand that.
I wouldn't take the blame for that if I might, Your Honor, in a way, in dealing with these cases that I perhaps advise my clients.
I know that's something probably needs to be addressed. We've talked about recently on several of them because it's very frustrating to have people come and take time out of their day, out of their work. The state have to expend that just to quote, set it for a hearing. When if it's going to end up, if somebody did something, they need to take responsibility for it. It goes over so much more with me, I think with the state, with probation, and it should be something that someone is encouraged to take personal responsibility instead of saying, let's see if they can prove it.
If I might, I'll try to address that in the future.
I appreciate
I hate
it.
him to be warned by something that I probably recommend.
I mean, you've been on probation for so long to be making these kinds of mistakes, you know? I could revoke you right now and send you to prison for 20 years. That's how serious this is. It's not a game. And I know you've been on it a long time, but I get the whole argument, smoking marijuana is not that big of a deal. Well, it is if you're on probation.
It went like that.
Well, you got arrested.
No, I'm saying I made a mistake, but it wasn't, I don't just smoke weed, you know.
Well, but you have because you've tested positive a few times. So I understand that maybe you don't all the time like some people, but you have. And you got arrested for it, for having it. And so here's what I'm gonna do, Mr. Ellis, and I want you to take advantage of this because after all this time, you don't have the conviction on your record. You're about to get the opportunity of a lifetime. You've already gotten a huge opportunity. When I do things like this, what I'm about to do, and you don't take advantage of it, it is typically going to be a whole lot worse than if I were to just revoke you today. So I want to make sure you understand that you're being given an opportunity, finish this probation, and hopefully not have any more issues because it's going to be very serious if you don't. So I'm going to find that you, again, entered your pleas of true to counts 1, 3, 5, and 6 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke the probation. I'm not going to do that. I'm going to extend it that last year that we've got to extend it. So you've got 1 more year. You will be on the drop program. So you'll be tested more frequently. You're going to be on the high medium caseload, which means you'll have to report more frequently. That's the price you pay for getting in trouble, but it's a whole lot better than going to prison and having the felony conviction. If you do everything like you're supposed to between now and the end of that next year, you're off probation. If you don't, you're in prison. All right. Any questions?
Okay.
But would the court also order the MRT class that you had mentioned?
Yeah. So the MRT class was already ordered. I want that started within 30 days.
Yes, ma'am.
So you need to get a job if you don't already have one. You need to do whatever you do to buy that book. I want that class completed. No questions asked. I don't want you waiting until the last minute. It's 18-week class. I want it started within the next 30 days. That's in order. You understand? If you have any questions about any of your other conditions, don't wait for probation and then say, well, they didn't tell me something. Go say, am I doing everything I'm supposed to be doing? I don't want to go to prison. Okay.
One person.
What's that?
On the fees, but what am I supposed to be paying? Cause I keep hearing
I don't-
supervision for you.
So here's the thing, talk to them. They can explain, there's different, you had fees, you have fines, you have different parts of that. You're supposed to be paying it all. And certain things that you pay go to certain parts of that. And they'll put it towards different things. Talk to your Miss Kane will explain to you what you've paid, what it's gone to, and what you still owe. Okay? But just ask her. All right? Okay. You're free to go. Thank you.
Thanks.
Okay, and so will Mr. Frazier waive the formal reading of the indictment?
He will, Judge.
Mr. Frazier, in cause number 25, DCCR 1494, the state has elected to proceed on count 1 only. It alleges that you committed the 3rd-degree felony offense of giving a false name or forging a vehicle registration from July 6th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Gertz?
I did.
Do you fully understand them?
I do.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Nice.
And it looks like the agreement is for a 2-year deferred probation. There would be a $750 fine. There would be restitution. It says for sales tax, and that would be, you guys can work that out with probation and we'll get that amount of restitution when we come back for sentencing. Also, this has an agreement that you would be able to travel for work. I do want to make sure you understand that that's not just a blanket. You can travel without letting probation know. You're still going to have to get permission to travel. My screen just went black. I'm sorry. You still are going to have to get permission or at least let them know job dates, things like that. Okay. It's not just a blanket. You can go wherever and we don't know where you are. Does that make sense?
It makes sense.
Okay.
And Judge, that was an important point in our negotiations, that he be required to communicate where he's going, but wouldn't have to come to the court every time. And
Well, you don't have to come to me, but you have to go to probation.
And just
So the permission to travel typically comes from probation unless there's some issue and they say, we don't think it's a good idea. So you still have to go through that. I'm saying now that I want you to work, and what's the job?
Oh, I go to auctions, and that consists of going to different states. Like, so when you win a vehicle, you have 48 hours to pick it up. And I have to be there, pick it up. It's a daily fee if you're not there on time.
Okay, so I'll look some more at that at sentencing. Is this the, I just feel like that's kind of something that has to do with the underlying offense, and that gives
And
me
we
some
made it
concern.
very clear that it would require the okay of the court, maybe not in person, obviously present here, but that
Right.
it would.
So, I mean,
require
you're
the
gonna
okay.
have to, 48 hours means you're gonna have to get with your probation officer and have that understanding that you're bidding on whatever the process is. It's, you have to have that permission before you go. All right, so if it costs money, if you, whatever happens, you cannot go out of Jefferson County without probation giving you that okay. I'm telling you it's gonna be okay, and you don't necessarily have to get my permission, which obviously would take much longer. You have to be in constant communication with your probation officer, more so than most people, because this is your job. And if you want to be able to do it and be on this probation, you're gonna have to take those extra steps. Okay, all right, state tenders number 1.
We have no objection, Judge.
It's admitted. Is there any evidence that Mr. Frazier is not competent?
None at all, Judge.
All right, so I'm going to find, and you're a US citizen, correct? I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so we can get the probation department to do that pre-sentence report. And then we'll come back later for sentencing. They'll get the restitution figured out. Go ahead and visit it with them when you're there about your job and kind of how it works so that they have a better understanding of that. When you get on probation, then hopefully that will go very smoothly and you can know how to get that taken care of. Is there something else? Yes, ma'am.
Just if I may, Judge, with respect to what the court stated about the nature of the offense, et cetera, I would like a little room to at least discuss with the court the possibility of asking for a few other things that go along the same line with respect to auto titles, et cetera, especially with regard to Jefferson County and tendering those here at Jefferson County at least during that term of probation, based on the fact that he is indicating to the court that it's still going to be a type of business that he's in. And I don't want him to be surprised by that.
Yeah, no, I mean, we'll see what all comes back, but once I have a better understanding after reading that pre-sentence report, there could potentially be some additional conditions.
Right. Thank you.
Okay, all right. Stop and talk to probation on your way out of the courtroom, please, sir. 6 is that he failed to provide verification of performing community service hours. 7 is that he was at a location other than his residence at after curfew. And then 8, which is when he pled true to, was fees. And so y'all remind me, we're here, Ms. Malfina's state has witnesses with regard to at least some of those. Is that correct?
Yes, Judge, I would ask, please, that the court take judicial notice of the original PSI and cause number 23 DCCR 1225. I have a hard copy here for the court if you'd like to review that.
Let me, should have it here. I've got mine, I'll print it out. It's got my notes on it as well, so.
And also, Judge, just to refresh the court's memory, this was set last week. We had a corresponding officer, for lack of a better term, that was going to be here on another hearing today. So I asked the court to put this today just because that officer who works graveyard is going to be here already. That case has since been moved to a later date. The arresting officer in this case, the one named in the new evading officer laws, possibly due to no fault of his own. I just want to make it clear that it was me who requested this quick turnaround and probably inconvenience to everybody. So that's totally on me. We've been unable to reach him. My investigators have made several attempts. He is not here today. Again, I'm not pointing the finger at him because he may have had an extended time period off. I just have made every effort to have him here today, but have been unable to have his presence secured for this hearing, Judge. But I do have Ms. Lopez from the probation office, based on the fact that there are several administrative violations that she can go over that have been pled not true to, and also to get her thoughts for the court's input, we will either let the new case rise and fall on its own, depending on the court's decision, or take some appropriate measure with respect to your decision to satisfy that case. For example, if it's ISF or something like that, of course, we would dispose of that case in a manner that would allow him to go on to ISF timely. So that's kind of where we are. Again, I'm not blaming the officer, but we've made every attempt to reach him and have been unable to do so. So that's, I don't have a lot for the court, but that's what I'm doing.
So I guess a couple things we could do. I mean, obviously the other allegations are important, but that's the main allegation. And so we could start the hearing. I could hear the evidence, and then we could recess the hearing and see if we can get him here. I'd like to have that information. I think it makes a big difference on, primarily because what he's on probation for is evading arrest with the vehicle, and the new alleged offense is another one. And so I think that is a serious enough allegation of the same sort that me just making some decision because there might be some possible missed communications, not necessarily missed communications with the officer to get him here. I think it's obviously very important that we get him here. And so I think I'm more inclined to listen to what everybody has, make some notes, and then hold any decision, reset it a week or two at the most. And I want to have a hearing and if it's just him, it may be something that we can do on a regular docket at the end of the docket.
Yes.
So, all right, so let's go forward with what you've got. Then you may call your first witness.
Thanks. I will call Ms. Lopez.
Good afternoon, ma'am. If you'll please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You can have a seat.
Thank you.
You may proceed.
Judge, Ms. Lopez, please state your name for the record.
My name is Rachel Lopez.
And how are you employed?
I'm a probation officer with the Jefferson County Probation Department.
And as such, do you have an opportunity to supervise an individual by the name of Accordion Dion Guillory?
Yes.
And do you see Mr. Guillory in the courtroom?
Yes.
Please point to him and identify what he's wearing.
He is at the defendant's table in a gray sweatshirt.
Your Honor, may the record reflect that Ms. Lopez has identified the defendant.
The record will so reflect.
And Ms. Lopez, obviously, everybody is aware for purposes of this hearing, the nature of probation and what rules and regulations individuals are ordered to follow based on this court's probation is to commit a new offense clearly against the rules of probation.
Yes.
We have alleged in the motion that Mr. Guillory has committed the offense of evading detention in February of 2026.
Yes.
And it is also the underlying type of offense for which he's in probation and has been on probation for only 1 year.
Yes.
With respect to that, do you have any additional evidence based on your own knowledge or review that you would like to impart with respect to that evading, or should that better come from the officer who stopped him?
It should better come from the officer because the only thing I do have is the officer's report from that evening.
Okay, and in that context, it was reported, and in fact, Mr. Guillory has pled true to the fact that part of that offense involved his being in Harris County, correct? At some point in time, either purchase a vehicle, some point in time, would that in and of itself, which he has pled true to, be a violation of his probation?
Yes.
Was he also ordered as a condition of this court's probation to work faithfully at suitable employment and provide you verification of such?
Yes, he was.
And has he done that?
No, he has not.
And that is in violation of his court order of probation, correct?
Correct.
And in the same context, has he failed to provide documentation verifying the source and amount of his income, most specifically related to a 2025 tax return?
Yes.
And did you ask him to provide you this information?
Multiple times.
And he did not?
Correct.
And would that have been in violation of his court order of probation?
Yes.
Was he also ordered by this court to provide and maintain an accurate residence address with his officer so that you or this court could locate him at any time?
Yes.
And did he do so?
He provided me an address at each of his office visits, but when he was questioned by the officer in the officer's offense report, he gave a different address.
Objection, hearsay.
Overruled.
So you had the two addresses listed in the motion, correct? The
Correct.
address there at Rusk and the address on West Lucas.
Correct.
And pursuant to the totality of this motion, came to your attention that yet another address for Mr. Guillory, which you did not have, had been associated with him.
Correct.
And again, it's just important that you have that information so that you, any of your officers or the court could find him at any time
Correct.
for a home visit or any other reason.
Correct. Or for instance, if I need to reschedule an appointment, I'll send a letter to that address, the address that I have, so that they know, that by no fault of their own, I'm needing to move their appointment.
Correct. And was Mr. Guillory also ordered as a condition of this probation to perform and give you verification of performing community service hours?
Yes, and so this should be noted that Mr. Guillory had previously performed community service, and then he started to have some violations. And so within our office, we have the option to reinstate previously waived community service hours. That's part of our community service amendment, is that when we ask to have community service hours held in abeyance, we have the ability to reinstate hours should we feel the need to. And so due to Mr. Guillory not doing what he was supposed to do, my supervisor chose to reinstate 50 hours of community service. And he has not completed those 50 hours.
Okay.
That's the 50 hours that we're talking about.
Okay. So although he has done some, there were violations that as a sanction thereof required reinstatement of some of those hours, which he has failed to comply with.
Correct.
Curfew is a condition of probation, correct?
Correct.
And was he in violation according to your review of all the documents of that curfew on February 27th of 2026?
Yes.
And would this go hand in hand with what he has previously pled true to as to being in Harris County?
Correct.
And lastly, he was court ordered to pay all the required fines and fees directed by this court with respect to his probation. And has he done that, or is he in arrears, or has he been in arrears at some point in 2026?
He is in arrears currently $2,202. He has not made any form of payment since January of this year.
And additionally, absent anything that Officer Moss or any officer from Beaumont Police Department would have, is there anything that you would like to add for Judge West while you are hearing under oath on this case?
Additionally, I was not able to check GPS tracker. He's on bond for his current case. And one of the conditions is that he have a GPS tracker. I was not able to check that last week because I was out of county in a training. But when I checked today, it was found that he was out past curfew on July 4th.
And had you been in the office last week?
I would have been able to check more accurately before today, and would have been able to submit that to the court sooner, but I only returned back to the office today.
This morning, right? And had I not requested this hearing so quickly, in the ordinary course of business, the court could have anticipated us filing the First Amendment.
Correct, and I do have documentation of that from the GPS tracker website if that's needed.
Thanks, Kathleen.
Thank you. Mr. Kimler?
Good afternoon.
Good afternoon.
You say it was out past curfew, the GPS indicated he was out past curfew.
Correct.
July 4th.
Correct.
What was the address that that's pegged to be able to say he's out there?
If you use it as 2120 Ashley Street of Beaumont, Texas.
And is that the address that you've had for him throughout his probation, or has that changed?
That's changed.
When was that updated?
His GPS, the address that he has for his current GPS is a Longfellow Avenue. And then he was at 2218 Rusk Street before that.
So Ashley is the current address that you have for him? Or
No, Ashley is the address he was at when he was in violation.
My question was, what was the address that you had for him as his residence location?
2218 Rusk Street.
That would have been July 4th, is that right?
No, he had it as a Longfellow I don't know the exact address for Longfellow.
So what is the Rusk address?
The Rusk address is where he lived before he was on GPS. He told me at his last office visit that he has moved into the Longfellow address since he's gotten the GPS tracker.
Back when the allegation is that he didn't provide you with the proper residence address, what was the address that you had then?
Then it was 2218 Rusk Street.
Rusk. And the address that he provided to law enforcement is indicated by the report.
Can I look at my
Yes,
report?
sir.
Because I admittedly don't have that memorized. That address he gave was a 2450 West Lucas Drive, apartment 37.
Was that where he was located when the officer encountered him? Or do you know?
I'm not aware of that.
Do you know, I guess the allegation would be that would be the address he was living at, and that wasn't his current address?
Correct. That was the address he, at least according to the offense report that I have, he told the officer that was where he was living at that time.
And we maybe can take that up with the officer. Do you know have you ever reviewed his state issued ID or driver's license?
He does not have one.
Okay. Do you know the address that he was booked in the jail under?
I do not.
Have you ever had mail returned to you from the Rusk address or not?
I do not believe so.
You ever did a home visit there? Was he there?
I have not.
So the allegation that he didn't give you the correct or didn't update his residence address is predicated on the address that he gave to the officer.
Correct.
Nothing else?
Nothing else.
How far behind is he on community service? 50 hours?
50 hours. Yes, sir.
And as far as maintaining suitable employment, he never provided any kind of proof that he was employed?
He has told me throughout his probation that he is either looking for employment or he is doing side jobs. But he's never given me any proof of that in regards to hours logged or anything like that. And as far as actual gainful employment, I've never received any form of paycheck stub or anything of that nature.
Any kind of, any indication at all that he's employed at all has been provided?
Not as of this filing.
Suitable employment, I guess, means legitimate legal work.
Something that you can file your taxes for.
Yeah, 1099s.
Yeah. Correct.
Passwords.
Ms. Nolfino?
I don't have anything additional. Judge?
Thank you, ma'am. All right, any other witnesses?
Not from the state judge, the court will indulge us with respect to Officer Moss. I will make every effort to have him here either tomorrow, Monday or Tuesday of next week.
Yeah, let's do this. Let's,
Every-
I would rather go ahead and make sure I don't want to set it for tomorrow and then you not being able to get in touch with him. So let's do it next Monday. At the end, the 10 or 11 o'clock, once we're finished with the docket.
You want him here?
9 o'clock. I want you here at 9 o'clock next Monday morning. And get in touch with Officer Moss and we can go through what we need to at the end of next Monday's docket. And but before, do you have any evidence then with regard to Mr. Kimler, with regard to any of the other, you don't have any witnesses with regard to the administrative stuff that Ms. Lopez?
I would call him for explanation, Your Honor, but would rather call him after the officer.
Okay, so we'll take care of that at all
I
at
don't
that
think
time.
he's very involved in that.
Okay, so just to make it, I want to make sure so that if for some reason Ms. Lopez cannot be here, at least for the address. And I'm taking judicial notice of the court's files in both cases, and y'all can figure out where this all came from, but I do have the probable cause from the new offense, and the address on that was either given or given in some type of ID form was the 2450 West Lucas, and the address that you had, Miss Lopez, was the 2218 Rush Street. And then the curfew from July 4th, which do you guys have what I'd like between now and next week? If there's time, do y'all have time? If there's going to be that allegation, if y'all want me to take into consideration an additional curfew violation, get that administrative done very quickly. Can you get that motion amended before next, are you okay going forward next Monday with that addition? So if y'all can get that done, then we can definitely, I can take that into consideration and you can talk about it with whatever you need to with regard to the curfew and the GPS and get those documents, if you would, to Ms. Smallfino so she can make sure that Mr. Kimler gets to take a look at those GPS documents. Okay, so what I'm going to do then is recess this hearing until next Monday during our docket, be here at 9 o'clock, but we'll do it once we have a break that's sufficient enough. Ms. Smallfino, if you find out for some reason from the officer that he cannot be here or refuse, if you need my help on anything, let me know. Okay, thanks.
Most people think the hard part is over once they plead guilty. But for one defendant, the biggest mistake came after he left the courtroom. Corbin Riley returned before the judge expecting to move forward with sentencing. Instead, the hearing took a dramatic turn the moment the judge revealed she had received a troubling memo from the probation department. According to the report, his behavior during the pre-sentence process had become so disrespectful that probation staff refused to complete his report while he remained out on bond. The defendant immediately tried to explain. He insisted it was all a misunderstanding and claimed he was only trying to get information over the phone. But the judge wasn't convinced. She reminded him that the probation department is known for being patient and said they would not have sent such a serious memo over a simple request for information. She warned him not to interrupt and told him it was time to stop arguing and start listening. Then came the moment that changed everything.